Okay, hello, welcome to your video email. Instead of me typing, I'm going to talk. All right, so here's some general feedback for your submissions. Overall, really good job, everyone. You will get your submissions back in class this week with my specific comments as to your actual submission. But generally speaking, there were some pitfalls that many, if not all of you, fell into. Number one, in this class, we have two spaces between every sentence, and a citation is a sentence. In fact, Blue Book calls citations citation sentences. Fun fact for your day. Two spaces. I understand that modern style is going to one space between every sentence, but I will fight that until I die. In my class, two spaces between every sentence. A citation is also a sentence. Thank you. All right. Number two, this without a noun, this being the pronoun without a noun. This is a common way that we speak. It also, this without a noun can find a happy home in poetry or other creative writing endeavors. In legal writing, it's bad style. Here's why. Let's take the pair of sentences. Jill hates peanuts. This can be seen in her avoidance of Reese's cups. Okay, so this, technically speaking, refers back to the last noun, which would be peanuts. But you would not have meant, when you said Jill hates peanuts, this can be seen by her avoidance of Reese's cup, you would not have meant this peanut can be seen, because that's not what you meant. What you meant was this fact can be seen by the fact that she avoids Reese's cups, yes? So if you mean this fact, say this fact. Here's why. Especially for legal writing, and you all know how much you read as a student. Think about how much you will read, because trust me, it will be more. And judges read hundreds and hundreds of pages a day. They can't read every sentence. Every time you make the reader, a legal reader, put a word in your prose for you, you are making them think about something that's not the merits of your case. You don't have time to do that. You need the legal reader to be thinking about the merits of your case every second that they're reading. So when you have a lazy style like this without a noun, you're making your reader do too much work, and then they're not thinking about the merits of your case, and that is never good for your client or you. So what you would want to say is, Jill hates peanuts. This can be seen. This fact can be seen by her avoidance of Reese's cups. This, brings me to my next point, which is many of your sentences could be more simple, actually, than you write them. So the sentence, this fact can be seen by her avoidance of Reese's cups, is an accurate statement of her avoidance of Reese's cups, I'm sure, but the sentence as a whole, the thought as a whole, could be brought about more simply. You could just say, Jill hates peanuts, and as such, avoids Reese's cups. It does a couple things. First, instead of avoidance, a verbal noun, now you're using avoids, the actual verb. That's always preferable as a matter of style. But also, I've cut down on the number of words, and the whole sort of phrase can be seen by is sort of a futzy phrase where no one word can be seen by has particular amount of meaning or impact, right? So that's a bit of a lazy style, right? So Jill hates peanuts. This fact can be seen by her avoidance of Reese's cups, right? Is fine, but Jill hates peanuts and as such avoids Reese's cups is a little bit better. Yes? Okay, think about it. All right. Number three, referencing, I think actually all of you reference counsel instead of party names. And I understand why you're doing this, right? In our record, we have letters from Facebook Counsel to the Council of the Real Parties. We have subpoenas being filed obviously by an attorney. But when you talk about filings and letters going back and forth in legalese, you don't speak of it as the lawyer doing it, right? The lawyer's doing it on behalf of their client. So real parties are filing subpoenas, right? And providers are responding to them, even though obviously it's the attorney doing it. That's not how you talk about it. You don't tend to see attorneys mentioned by name unless you would obviously see it in like if you're trying to sanction counsel, then you're talking about the counsel versus their client. But it's not common to do what most of you are doing, which is to say, Susan Kaplan, counsel for Real Parties, filed the subpoena. Is Real Parties filed the subpoena? Does that make sense? So go back through your work, and I've noted this on, I think, every submission. You just need to take the counsels out of it and just have the real party or the providers doing it. Which brings me to how to call the parties. I think in reading your submissions, because we have this odd verbiage with the writ, right, where technically the respondent is the superior court and technically the petitioner is the providers, even though before the California Supreme Court, the providers are actually function as the respondent. Yes, this is all very confusing. I think it's easier. Just call the real parties and call Facebook et al. the providers, right? And maybe drop petitioner because it's a little confusing. Think about it. But I think that probably will read more simply. Okay. Yes. Oh, abbreviations I use. You will see on your submissions a couple abbreviations. And I wrote them out, but I think it will show in reverse in the video. But at any rate, if you see 2 hashtags, right, 2 number signs, that means 2 spaces. Each one is a space, space, space. If you see this, it means I want you to start a new paragraph. If you see this, it means you have a capitalization issue. If you see this, that means I'm wanting you to flip the 2 things, right? It might either be a thought or literally 2 letters like this, but there's an order flip. If you see nonsense here, it could be your word, it could be scribbling, it could be whatever, and then dashes underneath, that's me telling you I had a thought, but I was wrong and I want you to keep it. Okay? All right. Wonderful. Okay, back to my list. Oh, id. No ids at the top of the page. If you start a new page, you have to have a a short site, and you can't id the record. So every record site has to be a record site. Speaking of record sites, please go to the handbook on page 29 for the correct citation. We have a record. So you will see on page 29, again, I think this will be backwards. We have a record. You will cite it like this, okay? I am used to, I think Hastings has recently changed how it's doing that because we used to always do them in parentheses. So that's what I've been used to for Hastings, but our handbook tells us that we are all wrong. Let's do it like page 29, shall we? All right. Facts. Okay. Let's talk about narrative. Overall, I will say everyone's facts are a little bit more simplistic than they need to be. So, real parties, let's start with you first. So, a couple ticky-tacky things. First of all, there are 12 counts they're indicted on, and none of you have said this. The counts are in the record on pages 126 and 127, and it outlines all of them. You do not need to outline all of them, but for the sake of accuracy, you might say, indicted on 12 counts, including, the big ones being murder and attempted murder. Okay. Also, real parties, and some of you have noticed this because I can see where you're drawing facts from, but you realize you have access on page 128 and 129 of the record to counsel for real parties version of the facts, right? So I would seriously look at that and think about why counsel has picked the facts they've picked and what kind of narrative they're trying to tell. Providers, you have a very provider-friendly version of the facts in the opinion below. Yes, the opinion below likes you quite a bit. Okay, I will say, generally speaking, real parties, I'd really like to see you telling the story of how they don't have as much about your client as how there's quite a bit of circumstantial evidence regarding your clients, because you want to fundamentally be setting up the argument that you really do need this social media evidence. Providers, on the other hand, let's talk about you. So I think all of you, and understandably, because really this murder is not your problem, you've truncated the murder facts so much that it's difficult to understand what's happened and how the social media evidence is even necessary. So I would say for real parties, you if you're coming in at under a page on the facts of the murder, you're probably glossing over too much. And I also, for both, I would like to see more explanation of what's in the subpoenas. You can do this by just having an appendix and then referring the reader to the appendix with the full citation of or a full rendition of the subpoena. And here's why. I want you to think about your brief in this way, and this is how, and in particular your statement of the case. The idea is, right, you, in theory, could give your brief, right, to a reader, and the whole world is before them. And yes, they have the record, and yes, they have the other briefs, but they shouldn't need to go to them to get to anything that is relevant to the case. There might be some ticky-tacky details that don't really matter that can be found in one brief versus the other, but you want your brief to be a one-stop shop, right? So providers, right, you want the brief to be a one-stop shop about what happened in the murder, what happened, what are the subpoenas actually about, who are the providers, right? What is the SCA, and exactly what happened in the lower courts, right? This material is readily gettable by your Supreme Court reader, but you want to be a one-stop shop, right? Same with real parties. You want to be a one-stop shop, and you also want to leave the reader, when the reader is done with the facts, completely primed to hear your argument about why you need this evidence. So the statement of case has two functions. One, building credibility with your reader and being the one-stop shop, but also two, setting up the argument, right? So obviously, providers, you're much more interested in setting up the argument that the SCA is king. Yes? And because that's what you're going with. So that is why I suggested in class, consider having an SCA section within your statement of the facts. I will tell you, even though there isn't a sample like this in our handbook, it is completely legitimate, and this might be more applicable to providers than to real parties. It is completely legitimate to have subheadings in your statement of the facts, and you could have it be, the murder, the subpoenas, the SCA, and that way, you just have facts about each of those things under those subheadings. That is completely legitimate. You don't have to do it, but I do want you to know, as a matter of style, that is something that you regularly see in briefs, especially you definitely do for regulatory matters where things get quite complicated and there's a number of facts, and definitely class actions. You almost always see it with class actions. All right, at any rate, those are my general thoughts. I'm sure I will have many more, but I want to get us all on the same page for those. Have a wonderful weekend. This week in class, you will get back all of the submissions you have given to me thus far. You will be giving me and your TAs the second half of your draft. And you will also have a 5 minutes, we're all going to go for 5 minutes for oral argument, and that will be our class. All right, I will see you then. Have a great weekend. Bye.